Hello, this is Sri Bhandari. My greetings to all of you. Hope you and your families are doing great. The topic for today is whether a manually filed appeal can be accepted by the department where the assessment order is not uploaded on the GST portal. Before discussing the case of Sri Lakshmi Venkateshwara versus State of Andhra Pradesh in detail, let me just quickly answer the question that I just put forward. Yes, a manually filed appeal should be allowed where the assessment order is not uploaded on the GST portal. Now, let's dive into the facts of the case in detail wherein the acceptance of a manually filed appeal was decided. Facts of the case. The assessee is a dealer in edible and non-edible oils and is registered under the AP-GST Act. The department conducted an inspection on the assessee and issued a show cause notice. The show cause notice was issued under the AP-GST Act in form DRC-02. After the issuance of the show cause notice, the assessee filed an explanation. However, the department passed an assessment order fixing the tax liability for the period July 17 to February 18. Another assessment order under the CGST Act for an equal sum of tax was also passed on the assessee. Aggrieved by the two assessment orders under the AP-GST Act and the CGST Act, the assessee filed an appeal within a period of 3 months from the date of communication of the order, along with a proof of payment of 10% of the disputed tax. As the order was served on the assessee manually, the appeal was also filed manually, and the assessee also obtained an acknowledgement from the proper officer. Later, a check memo was issued stating that the appeal will be rejected because the same was not filed electronically. To this, a response was filed by the assessee stating that both the assessment orders were served on him manually and not electronically, therefore the appeal was also filed manually. However, the assessee admitted to the fact that he did try to file the appeal electronically, that went in vain. However, the appeal was rejected on the sole ground that the same was not filed electronically. Now, let's discuss the relevant section under the CGST Act. As per section 107 of the CGST Act, an appeal has to be filed within a period of 3 months from the date of communication of the order. Discussing the case, the assessment order was passed on the assessee on 30th of May 2018. The said order was received by the assessee on 5th of June 2018, and the appeal was filed on 28th of June 2018, which is well within the time limit of 3 months. Held that the department does not have an authority to reject the appeal because the same was filed within a period of 3 months along with a proof of payment of 10% of the disputed tax. The department was further asked to admit the appeal and process the same as per the governing laws and rules. Thank you. Have a good day.